Thank you, Mr. Chairman. Mr. Chairman, members of the committee. Very rarely do I testify on legislation anymore since I've been the chairman of the Committee on Senate Ways and Means. I know exactly how uncomfortable the springs are in the chairs that you're all sitting in right now, in more ways than one. I am the father of two daughters, aged 21 and 26 years old. If my children needed access to healthcare information and services, I would not want them to be accosted. I'm reminded when we run for office that you want to ask somebody to vote for you, you have to be 150 feet away from the polling to vote. Many years ago, as a public safety measure, I supported a buffer zone. A place, no one walks in to a reproductive health clinic with a smile on their face. And no one walks out with a smile on their face. 52% of our population are women. We men ought to be standing up for women and their right to not be abused, accosted, embarrassed, pained, or any other thing when they choose, sometimes not by their own choice, but circumstances, to go to a reproductive health care. The people who work there have to work behind bulletproof glass, more secure, oftentimes, than the fortresses or the pharmacies that dispense serious drugs nowadays. We can do better than that. I'm leaving this building in 14 more days as a state senator. I'll be here as a senator in January. After 35 years, probably more than some of you have been alive. I've seen a lot of activities at Gardner. I was in a classroom in 1968 at the University of Massachusetts when a man named Bill Baird held up a pill, a birth control pill, and he was arrested for showing a birth control pill in public. Think about how far we have gone. Think about how far we have gone. In the interest of fairness to our fellow citizens, we write history for our children to make sure that they're not treated like some pariah when they're making the most difficult decisions in their lives. I believe that the Attorney General, the Senate President, and Speaker have crafted the governor is logical, a fundamental, basic right to protect a constitutional right of our citizens. I hope that this committee does report a bill unfavorably very, very soon. Thank you for your patience.
Thank you for your testimony. No questions from the panel. Thank you very much. Governor Gardner. Welcome, sir. Thank you very much for joining us. Yes, please.
Thank you. Chairman Gardner, Chairman Markey, members of the committee, good afternoon, and thank you all for convening this hearing and for doing so quickly. In light of the important public safety and reproductive health issues addressed in this bill, it's very gratifying and encouraging that you've done so. I have to confess that the Supreme Court's June 26th decision confuses me. It's hard for me to understand, given the court's modern jurisprudence, a conclusion that says that one person's constitutional right cannot be exercised without infringing another's constitutional right. Fortunately, the court provided us with a roadmap to follow to what would be constitutionally acceptable, and this bill, the Safe Access Bill, proposes that course. The issues at stake are not abstract. Women and men seeking access to reproductive health care services face human fences that obstruct their paths, protesters pacing in driveways to make it harder to enter parking lots, and signs used to obstruct the patient's access to the door. From intimidation to outright killing, experience in the Commonwealth has demonstrated that there is a pressing need to ensure that women and men seeking reproductive health services can do so safely and without harassment, and that the employees of those facilities can arrive at work each day without fear of harm. A person who objects to abortion has a right to express that view, but a person seeking health care also has the right to feel safe. The court demands we better balance these rights. The bill before you today strikes that balance. The right to choose whether to keep an unintended pregnancy is deeply personal and a matter for patients to work through with the help of family, faith, and medical advice. That requires and deserves an appropriate and safe environment. This bill, we believe, accomplishes that by enhancing existing laws and creating new protections that promote public safety. Neither our commitment to protecting a woman's right to access reproductive care nor our dedication to the First Amendment have changed. The Safe Access Bill speaks to those constant truths. We will allow Massachusetts to once again ensure that a woman's ability to seek reproductive health care services in the Commonwealth is secure. So I want to thank you, Mr. Chairman, and thanks to all of the committee for your swift action. I also want to thank Senator Murray, Speaker DeLeo, Attorney General Coakley, Planned Parenthood, NARAL, and many others who worked with us on this bill, along with many thousands of our citizens, and I am counting on the legislature to pass this bill quickly before the session continues at the end of this month. Thank you all for your time and your thoughtful consideration.
Thank you very much for your testimony. Thank you for your leadership on this. Would you give us any questions from the council? Any questions from the council? Thank you so much for being with us. Very much, Mr. So now we are back to our representative.
Thank you, Chairman Brownsberger, Vice Chairman Markey, members of the committee and staff. I too also offer the testimony to support the Act to promote public safety and protect access to reproductive health care facilities, filed by Senator Chandler in response to the U.S. Supreme Court recent decision. This bill, under consideration, appropriately balances public safety, privacy, and access to health care services with the free speech rights of individuals. All residents of our Commonwealth deserve dignity and privacy in seeking health care services, free from harassment, intimidation, and coercion. Building upon the Freedom of Access to Clinic Entrance Act and the Massachusetts Civil Rights Act, this bill simply enhances the ability of law enforcement officials to maintain public safety outside reproductive health care facilities, ensuring a clear passage for patients. Further, it provides the ability of aggrieved parties and the Attorney General to seek court action to enforce these rights and protect vis-a-vis the most extreme behavior of those that abuse the responsibility that comes with the right of free speech. I've had the privilege in my previous job to work in 22 countries and teach over 10,000 people from 22 countries about diversity and inclusion. And one of the very tough sticking points is when there's a fundamental disagreement or different philosophy of some of the tough choices. One of those, of course, is choosing to terminate a pregnancy. And what we've taught in those classes since 1996 around the world is that there are some issues we will never agree on, and we don't have to. However, we do have to care, have equality, justice, and respect. And this is a chance to move this bill ahead to create that kind of world for all of us. So I respectfully urge and support the committee to act swiftly and support this bill favorably. Thank you for your time.
Thank you very much. Any questions from the council? Thank you. Returning to our list, Leader Russo.
Mr. Chairman and members of the committee, my name is Rita Russo. I live in Norwood, Mass. I am a retired obstetrical nurse. I have witnessed the very rocky transition of an America that guaranteed life, liberty, and the pursuit of happiness to all, to an America that has legalized the killing of its unborn children, the killing of 1.2 million a year. I have prayed outside abortion clinics at least once a week for 7 years. I am here giving testimony as an individual, but I have been campaign director for 40 Days for Life Boston for the past 2 years, which consists of having participants pray and fast, keep peaceful vigil outside Planned Parenthood, and do community outreach. We are totally opposed to any form of harassment or violence. Our vigil is prayerful, peaceful, and respectful. Our right to pray in the public square is protected by the rights to freedom of speech and freedom of religion. The proposed law will lend itself to abuse of these rights, to lies, intimidation, and false interpretation. This is America and not a police state. Our freedoms are precious to us and must be preserved. If women entering abortion facilities only hear the information provided by those who will profit from their abortions, they cannot make informed decisions and they will never hear what help is available. If Planned Parenthood gave them this information, we would not need to be there. But they profit from this process. The members, this procedure that the women go in for is not a mundane and benign process. It is not a routine checkup or dental appointment. It is life-changing and carries with it significant mental health and physical risks. The members of the pro-life movement have no financial gain for what we do, yet we are at the mercy of those who lie and slander us to protect their financial profits. I was greatly offended this afternoon hearing the slander of Mrs. McCollum. It is well documented that women are hurt by abortion, but lies to cover it up are perpetrated by the industry. Women will be better served by giving them truthful information and letting them make informed decisions. We already have laws to prosecute people who are out of line and have extreme behaviors of violence and harassment. Please defeat this bill. It is anti-women. Thank you.
Thank you very much for your testimony. Any questions from the panel? Thank you for your patience this morning. I appreciate it. Monica Highland. Monica Highland. Lisa Barstow still here? This is speaking in the private and issues and that will pass. To a short summary of the testimony. Brian Campbell. Brian Campbell. Is he outside? Oh, there you are, sir.
Thank you. Most of what I was going to say has already been said, so I won't say too much. But I think that there are some important points that I'd like to reiterate. One is that there are, as has been pointed out, some very presumably unconstitutional parts of the bill. That those having to do with the dispersal, those having to do with the onerous fines that are up against people who are supposedly blocking abortion clinics, but not against other people who might be committing crimes but not doing that, but not blocking the abortion clinics. And in particular, I think that the lurid stories that you've heard about harassment, that even the U.S. Supreme Court has said there is no corroboration for it. I think that the point being made, and you need to think very clearly about this, that if there's no video, no arrests, no prosecutions, I think that you need to say what's really going on here. Just yesterday, I spoke to two pro-life people who regularly are outside of abortion clinics, and both of them told me that they had been harassed and assaulted by pro-choice advocates. In each of those cases, the perpetrator was arrested and taken to court. In one case, the person was actually prosecuted and convicted. In the other case, the person allowed him, said, if you apologize, I'll drop the charges, and he did. What it shows is that these kinds of things are very easy to prosecute under the current laws. And the fact that there aren't any, I think, is something that you should really think hard about before rushing to judgment and pushing this through real fast. Because I think that it would be a great be struck down again. So that's my testimony. Thank you very much.
Thank you very much. Well taken, Mr. Gardner. You don't go away. Any questions for Mr. Campbell from the panel? Okay, thank you, sir, for your testimony. Thank you for your patience. Robert Murphy for the panel, Melissa.
Good afternoon, Mr. Chairman, members of the Judiciary Committee. My name is Gardner, Roderick Murphy. I'm the Director of Problem Pregnancy in Worcester. You're all Worcester folks here. Worcester is about 40 miles west of here. It's not Commonwealth Avenue. It's not Brookline. It's different. Anyway, we have 4 speakers against this proposal. And I'm going to each of them talk, and then I'm going to say something at the end. First speaker is Faith Kendall, mother of Michael, and a client of problem pregnancy. We have a photo. Where's the photo? We're going to send the photo down so you can see what Faith is going to talk about.
Good afternoon. My name is Faith. I'm a friend and a client of Brother Pregnancy. About 5 years ago, I found myself pregnant and I was confused, ashamed, angry, lonely. I had no one. And as I walked down Chandler Street in Worcester looking for a solution, looking for an abortion facility, because I thought it was the easiest way out, I happened to meet several counselors from Problem Pregnancy. I didn't know who these people were, but the way they talked to me, the way they addressed me, they gave me hope. So I went to the facility and they told me that they would support me, they'll be there for me. They told me the choices I had, and they said the choice was made for me. No one coerced me, no one forced me. I thought about it, and 4 years down the road, that's my baby boy, the cutest baby boy ever. I had a chance to finish education, and I'm working. My baby is growing beautifully, and I'm a proud mother. So what I want to say is that many young women or many people find themselves in this situation, a situation that I was faced with, and they tend to make a drastic decision because they are confused or they don't know who to turn to, they don't know who to talk to, and they think that the easiest way out is abortion, as I thought. But if we have counselors, pro-life facilities, or other agencies that we can go to and we feel supported and we get the support, I mean, life can be saved and a world can be changed. Thank you.
We now have Mrs. Nancy Clark, one of the common plaintiffs, and a sidewalk counsel who peacefully offer needy women alternatives to abortion on public sidewalk in Worcester. Nancy.
Hello, I'm Nancy Clark. I actually didn't know I needed to be prepared to say anything today. As a sidewalk counselor, it has been very nice since the buffer zone has been lifted for me. When I stand over there, I have never harassed anyone, and I have never had any intent to push or hurt anyone. All I've ever done is try to offer help to girls that are in a situation that maybe none of them are in a good situation, obviously, when they're hanging in there. And I really think that most girls do not want to even be going in there. talk to people not screaming, it's been much nicer. I just feel like that this law, only one person would be allowed near the zone. Is that what they're saying? Only one person? I'm not even supposed to be there alone. You should have someone standing with you when you're in there because you do get people angry. People do come out, there are, usually it's the man who will come out and scream at me or something. And when if they do, I will back off. But allies are in danger as well if we're standing there alone. And have someone come out together. You're supposed to have somebody with us as well. So I'm only there to help. I never want to hurt. And it's just, we need to really think about taking away our rights to be able to stand there to just offer help. Thank you.
Mrs. Nancy, excuse me, Mrs. Lee Crowley, another sidewalk council, helping others in front of my parent also.
Good afternoon. When I'm outside the town area, I'm very careful not to block anyone on the sidewalk, whether they're customers or passers-by. If I have a chance to talk to someone, I tell them that if they need help, there's help across the street. If they're interested, I can start a conversation, and if not, I back off. The buffer zone kept me from speaking with people because I had to raise my voice across 2 lanes of traffic. Now it's much easier to start a conversation in a normal and friendly tone. This past week, I was able to speak with a girl who told me she did in fact need help and wanted to talk because it was her first pregnancy. She felt she had no choice but to abort, but she was scared. I told her she could sit down with a counselor in the center across the street, and she went in. I might not have gotten that chance with the buffer zone. She might not have gotten that chance. Like the buffer zone, this new law will suppress my right to free speech and the right of those going to the clinic to hear about alternatives to abortion by trying to scare me away from the sidewalk. The way the law is written, I can face arrest and civil action based on someone's whim. ST2106 says the person who intimidates or impedes access can be arrested on the spot. Who decides what constitutes intimidation, or if it was unreasonably difficult for someone to pass by? Although some of these terms are defined, they're still subject to interpretation, and the law states further that these definitions may not hold if the context clearly requires otherwise, whatever that means. Given that the Attorney General, the Governor, and other people who crafted this law have stated publicly and strongly that they disagree with my beliefs, I don't think it's unreasonable for me to be concerned that this ambiguous law against intimidation could be used to intimidate me for holding a point of view that's currently politically unpopular. ST2106 would take away my ability to speak to people on the sidewalk by creating a very real fear of reprisal from anyone who doesn't like what I have to say. I'd like to end with a quote from one I know very well, who chose not to have to schedule abortion after talking to sidewalk counselors. She said, quote, "They offered me a free ultrasound at the Crisis Pregnancy Center, and I finally agreed because they were very sweet and not threatening or judging. Once I saw that ultrasound, my baby moving, and all of her bones, I couldn't go through with the boarding. They told me there was help available and found me a place to live. I had no idea there were places that provide options for women, and I wish that more women knew," unquote. I wish more women knew too, and that's why I need the right to speak freely, to let women know that there are people who care, who can offer them help, hope, and love. Thank you.
Thank you, ladies. I have a couple of things. I will use Justice Scalia's concurrence words here. There is an entirely separate, abridged edition of the First Amendment applicable to speech about abortion. You are doing it here now. And he also thundered, protecting people from speech they do not want to hear is not a function that the First Amendment allows the government to undertake in public streets and sidewalks. He's doing it here. McCollum proves that your case, and your lawyers, are guts. Don't fight another losing battle in the courts. Leave us alone. Thank you.
Thank you very much for your very personal testimony. Are there questions from the members of the panel? No. Okay. Thank you very much for being here. Thank you for your patience today.
Thank you.
Do you vote? Sorry.
thank you all for taking this bill up so quickly and for hearing testimony. I want to thank Senator Chandler for filing this legislation. I was happy to be a co-sponsor of this legislation. I want to thank Senate President Theresa Murray for her leadership. Also partners who have worked on this issue like Governor Patrick and Planned Parenthood. I wanted to come here, even though we're in session, and I know we all are, so I have to be shortly, I will be brief. And basically, I would say that this bill is critical. This bill is not about just one procedure, but about ensuring women's safe access to reproductive health care facilities in our Commonwealth. So there are various aspects of the bill that you've heard about, no doubt, since this has been going on since 10 a.m. But I think women entering these facilities, it's important to make sure it's a safe environment, that the entrances as you go in and out are not blocked, that intimidation is not continuing. And so I think it's just critical that we do pass this legislation and that this committee votes it in the favor. So, that's all.
Nice job, very brief. Thank you, ma'am. Any questions? Thank you very much for coming down, Senator. Just make a second call because I want you to vote to enjoy it. Jean, vote for this? Here or not here? Janine, vote. Not here. Okay. And Rebecca? Last time you and Rebecca. Laura? Section? Sir.
Good afternoon. I want to ask you to vote no on Senate Bill 2106, and that would essentially give the policeman the power to create a 25-foot dispersal buffer zone. Please do all you can to protect the life of the innocent child that God has created and knitted in the womb. I ask you before God to judge the living and the dead, please vote against this bill. Every year, by God's grace, a few babies' lives are saved, and God has used sidewalk counselors to help the mother see that she has a real choice in keeping the baby alive. Why would you support this anti-choice bill? There's no violence on the street by pro-lifers. If there was, the co-cutters, the video cameras, and the police, as well as the victims, would be speaking out. The pro-abortion people have lots of money, government funds, and influence. But they are also bringing innocent blood to this land that is already polluted with the blood of millions of unborn babies. Pro-lifers volunteer their time to pregnancy organizations which offer real help to pregnant mothers of all ages and their children. This bill violates the First Amendment, which guarantees everyone the right to freedom of speech and religion. It's anti-speech and anti-religion. In case you haven't heard, the Supreme Court voted 9-0 on the last law, but that was unconstitutional. So why would you want to make another unconstitutional law? Public sidewalks are just that, public sidewalks. Can you imagine if City Hall had a 25-foot buffer zone outside of it so people could not protest? There would be an uproar. To make matters worse, the abortuaries are a private outfit who want control over the public sidewalk. Will they be required to pay for the public sidewalk too? What special interest group does the government get away with creating a buffer zone for? None. Can you imagine if the legal aliens, the union, or others were given a special law that just because of their interest, a single police officer disperse them 25 feet away? Please vote no on Senate Bill 2106 and seek God's grace to do His will. And I'd like to read to you the words of Solomon in Ecclesiastes. He talks about the end of life. Remember now your Creator in the days of your youth, before the difficult days come, and the years draw near, and you say, I have no pleasure in them. Remember your Creator before the silver cord is loose, or the golden bowl is broken, or the pitcher shattered at the fountain, or the wheel broken at the well, then the dust will return to the earth as it was, and the spirit will return to God who gave it. Vanity of vanity, says the preacher, all is vanity. And further, my son, be admonished by these. Of making many books there is no end, and much study is weariness to the flesh. Let us hear the conclusion of the whole matter. Fear God and keep his commandments, for this is the whole duty of man. For God will bring every work into judgment, including every secret thing, whether it is good or whether it is evil. Choose life from deception and natural law.
Thank you, sir. Are there any questions from members of the panel? Thank you, sir, for your testimony. Christine Funnell? No?
Thank you. Well, thank you, Chairman Rosenberger and committee members. My name is Christine Funnell. I'm from Medford, Massachusetts, and I represent Commonwealth Covenant Keepers, which is an organization I speak on behalf of those who adhere to the Judeo-Christian foundation of our Commonwealth. Who are here today. I have been in the fight against abortion since I first felt life in my womb in 1981. I don't remember having much of an opinion against abortion before I felt that life. That's why I prevent women from having more counseling before they choose to have abortion. I don't want to use the term access to health care because what we're really talking about here is abortion. Many of these women or teenagers need a chance to get some help and some support before they make this decision that they probably regret. My experience before buffer zones was very different. I used to take my children to preterm in Brookline and stroll it because I felt strongly and I wanted to let people know how I felt. I remember being harassed and intimidated by large women who kept asking why I was politicizing my children. They even took video of us, of me and my children, and other people who were there. I felt intimidation because I was expressing my belief. I was also a counselor later on at Daybreak Pregnancy Center in Harvard Square when it opened in the 1980s. All the women I encountered there were happy to receive the support and information they received about the procedure that they were contemplating. Many women changed their mind and even came back to thank us. And I usually remember the grandparents thanking me that their grandchild was allowed to live, that there was time given for their grandchild to be born. That are walking around today. I'm happy to think of those children walking around today. Abortion is not a settled matter in our nation. The people need to be heard on this issue and allowed to show their disagreement with the use of abortion. If no one is allowed to speak out, make eye contact, or take a woman aside if she is so inclined, pray with her. Wouldn't get the idea that it's publicly sanctioned. They're going to think that it's fine, but it isn't fine. And I believe that the people, that we need to allow people the opportunity to express our disapproval of abortion and our free speech. Thank you.
Thank you very much for your testimony. Are there any questions from members of the panel? Thank you for being here today. Robert Joyce.
Good afternoon, Mr. Chairman and honorable members of the committee. Thank you for giving me this opportunity to address you today. My name is Robert Joyce. I live in Rosendale, and I have practiced law in Newton in good standing for 35 years. I'm president of the Pro-Life Legal Defense Fund, but I'm appearing here today to give testimony as an individual and as a citizen. I testify in opposition to the bill. This Commonwealth's experience with the Buffer Zone Act illustrates how easy it is for lawmakers, whether intentionally or unintentionally, to misunderstand, defy, or disrespect the Constitution of the United States. In 2007, members of the General Court, many of whom were not lawyers, voted more than 4-1 in favor of an unconstitutional law. Those votes were cast after a lot of deliberation. You are being asked now to vote on another bill with profound constitutional ramifications. But you are being expected to do so without an appropriate opportunity for either serious individual study or calm deliberation with your colleagues. You are being told that a bill must be passed by the end of this month. I urge you not to follow that advice. Even in law school, students learn about the importance of that laws be clear and fair. Ambiguity in legislation always leads to litigation. There is ambiguity in this bill. The imprecise definition of the word gathering could easily force peaceful pro-life counselors to disperse if as few as 2 other persons are deemed to be impeding access. That imprecise definition would cause several peaceful counselors who are lawfully exercising their free speech rights to disperse based upon the offensive act of just 2 persons. That would unconstitutionally create a de facto buffer zone for peaceful counselors. The bill also subjects peaceful pro-life counselors to lawsuits and liabilities for attorneys' fees and damages, including punitive damages, because of another imprecisely defined word, intimidation. One Boston Globe columnist has asserted that even soft-spoken and polite pro-life counselors were still intimidating women. Planned Parenthood officers have reportedly testified that simple pro-life signs stating, "We are praying for you," and simple statements like,
Just to let you know, I'm just going up for a roll call in the Senate.
Sure. And simple statements like, "Mom, let us help you," and simply praying silently on the sidewalk constitute intimidation. Counselors can foreseeably be faced with accusations that simple statements like these can intimidate patients and contribute to cause bodily harm by dissuading them from receiving medical care. The Supreme Court found the Buffer Zone Act content neutral. It significantly noted, however, that a law which restricted free speech because it made some listeners uncomfortable would not be content neutral. Accordingly, such a law would trigger the more stringent constitutional standard of strict scrutiny, which the Commonwealth sought successfully to avoid in the buffer zone case. In your calm deliberations over time, you should seriously consider whether this bill will trigger strict scrutiny review and subject the Commonwealth to another expensive and successful constitutional challenge to the detriment of both women's health and to the free speech rights of our people. I urge you to defeat this bill and to take appropriate time for study and deliberation on this important issue. Thank you very much.
Thank you. Are there any questions?
I asked a question earlier in the day to folks who seem to have some deep knowledge of the constitutional law issues, and I'd like to pose this question to you. First of all, I looked at the Supreme Court decision in the column. It says, right in the language of the case, if Massachusetts determined that broader prohibitions along the same lines are necessary, it could enact
legislation similar to the Federal Freedom of Access to Clinic Entrances Act of 1994. So the Supreme Court, in its decision, is inviting us to consider another statute in this case. Now, the question is, from 1992, the United States Supreme Court upheld a buffer zone in voting booth situations. So any of us who have run for office, who have run campaigns at a polling place, understand that within 100 feet of that polling place, you cannot hold up a sign, you can't speak to people, you can't pass out literature. In 1992, the Supreme Court upheld that particular buffer zone. And I'm struggling with how some regulation, which the Supreme Court is inviting us to do in the McCollum decision, would be violative of that particular Supreme Court case.
Thank you, sir. Let me address both of those comments and those questions. You did properly cite language from McCollum saying what the Supreme Court said the Commonwealth could consider if it determined that more appropriate law, that more laws were necessary. Remember, it said if, and it also said could. What we learned in law school, and what we all know, is that it's important not only to read the opinion, but also to read the footnotes. And the footnote to that particular statement in the McCollum case specifically stated that the court was not expressing any indication as to its impression about the constitutionality of such statutes. That's a very important point. And as a matter of fact, both the governor and the attorney general and the CEO of Planned Parenthood have been quoted in the paper several times with statements such as, well, they've given us a roadmap, they've told us what to do, and we're just doing it. That's an erroneous statement. What they said is that this is something that you could consider, and we're not expressing whether it's constitutional. So my opinion would be we never challenged the Section E in the existing statute which prohibited blocking, impeding, hindering access. And we don't do that now, and that law is sufficient. We don't need a new law. As to your second question about the polling places, I mentioned in my testimony about strict scrutiny. I think that you will find that the right to vote and the freedom to vote there has been defined as, I think you'll find, as a compelling state interest. Accordingly, any restriction on it has to pass strict scrutiny. And I think that that's the answer. And I think that you're going to invite strict scrutiny if you pass this bill, and I think you're going to fail. Thank you.
Any other questions?
I had a quick follow-up. I believe you stated that the language, the definition of gathering was vague. What's the terminology used? Definition of gathering in the current bill. How did you portray it? I believe you said either it was vague or broad.
Yes. A gathering can be as few as 2 people. Of course, it can be more than 2 people. Let's assume hypothetically that there is a gathering that involves 20 people, 2 of whom are impeding, but the other 18 of whom are in favor, are part of the gathering. Those other 18, according to this statute, could be kicked back 25 feet without any judicial action by a police officer on the scene, and that would create a de facto buffer zone. Thank you.
No further questions?
Thank you very much.
Thank you, sir, for your testimony today. Eric, Ian?
Good afternoon, members of the Judiciary Committee and Senator Brownsberger. I'd like to thank you for your time and listening to my testimony. I submitted a written copy of the testimony, and so I would just like to add some brief remarks to that. And I believe that the thrust of my testimony goes to that answering the representative's question about how we should generally stop harassment at the clinic. And so I'll get to that. I've been a sidewalk counselor as a sidewalk counselor for over 20 years. As a sidewalk counselor, a Christian and pro-life person, my respect for life extends to all involved in the abortion issue. And I've had positive reactions with people going in, with Planned Parenthood staff, and even with counter demonstrators. In fact, when I was assaulted in front of Planned Parenthood, one of the Planned Parenthood staff offered to be my witness in court. I have seen the harassment go primarily against pro-lifers in my time there. I don't go out there to block people. I don't go out there to intimidate people and harass them. But when a business does not like, what I have to say, the content of my speech and law enforcement officials can misinterpret that, then that, I think, goes exactly to my First Amendment free speech rights. And I see that as what is happening on the street of Planned Parenthood. I think the buffer zone in itself is a physical threat, objectively, by pushing us into the street. I'm speaking about the Planned Parenthood clinic on Commonwealth Avenue, and crosswalk, which leaves us open to cars that are making fast turns around the corner there, and to other types of harassment from the street. 2 months ago, I witnessed a bottle thrown from a truck along with a stream of profanity, and this bottle missed by inches one of our female sidewalk counselors. So there really is, on both sides, I think there is a concern about harassment, and that goes to the representative's question. And how can we minimize this harassment? I would say that the legislature should pass laws that apply equally to all, not one that targets one group or on a partisan basis. There is harassment out there, and it needs to be addressed. And as I said in my testimony, a good and just law protects all citizens. This one simply uses selective enforcement to target a politically unpopular group with no history of violence or persecution.
Thank you very much for your time, sir. Are there questions from members of the panel? I want to thank you for taking time to testify. That completes the list of people who we think decided to testify. Is there anybody in the room who was here to testify that I haven't called? So what I'm going to do in a moment, so that no one wants to going twice, is close testimony. And then we'll take a brief recess and have an executive discussion on the bill right here in public, just to take action on the bill. So, closed testimony. And I would propose that we reconvene at 4:05 for executive session.